Hello, this is Justin Storch. I am the Global Content Strategist with SHRM, and I'm here at the Employment Law and Legislative Conference in Washington, D.C., and I'm talking today with one of the presenters who presented a session on I-9s that just ended. Her name is Becki Young. She is with Grossman, Young, and Hammond, and we're going to be talking about I-9s, the enforcement process, and different developments that have occurred recently. So, Becki, you noted in your presentation today that ICE announced last year it was aiming for a 400% increase in worksite investigations, and it has delivered on that promise. How have they materialized, and has the nature of such investigations changed in the last year?
So, as you point out, ICE has delivered on its promise. It made good on the 400% increase, and based on the year-end statistics, depending on the category, there was a 300 to 750% increase in various actions. For example, there were 6,848 worksite investigations. There were 5,981 I-9 audits, 779 criminal arrests, and 1,525 administrative arrests. So all of those figures represent an increase of about 400% over the previous year. The one thing that did not see a substantial increase were criminal indictments and convictions, but that's because these types of indictments take some time to work their way through the system. So I think we can expect to see in the future that there will be an increase in indictments and convictions, but that doesn't happen immediately. The government has been really vocal about their shift towards what they call a culture of compliance. So in all of their press releases and when they speak to the public, they use this phrase, culture of compliance. And they are really trying to get the message across that they will continue to operate at a really fast pace and do as many worksite investigations as possible.
So what type of penalties might employers face if they don't comply with I-9 laws and regulations?
For paperwork errors, which might be something like forgetting to include the date of birth or forgetting to include the I-94 number, employers could be fined over $2,000 per violation. For knowingly hire or continuing to employ violations, employers could be fined as much as $20,000 or more per violation. And in addition, employers can be criminally prosecuted, and ICE has specifically stated that it wants to increase its criminal prosecutions, and it has taken action in that regard. There were a few investigations in the past year. In August 2018, there was a multi-state action in Nebraska, Minnesota, and Nevada, where 17 criminal arrest warrants were issued to employers for collusion to create an illegal workforce. And also in August, there was a Texas trailer manufacturer which was raided, and ICE executed criminal search warrants for knowing hire and continuing to employ.
What are some of the common mistakes you see employers make in the I-9 process?
One of the most common mistakes that we see is entering a List A document, so a document that shows both identity and work authorization, entering that into List B or List C. Sometimes we see that someone enters a List B document or a List C document into List A. So that sounds minimal, but it is a finable offense. So we always encourage employers to be sure to put the document in the right place. Sometimes employers will write C attached instead of actually filling out the details of the document. That is not allowed and would be a paperwork violation. Sometimes if an employee has a specific end date, so they have an EAD, they have an H-1B, the employer is required in that situation to fill in either the A number, I-94 number, or passport number, but we often see that that has been forgotten. Failing to verify or re-verify in a timely fashion happens a lot, so you have to verify within 3 days of hire and re-verify prior to expiration, but that doesn't always happen. And finally, over-documentation, so collecting more documents than are required or re-verifying legal permanent residence or conditional permanent residence. Those are all errors that we see in the I-9 process.
So, Becki, in 2019, more and more employers are working remotely, which adds new challenges to the I-9 process. What are some of the tips for compliance when the worker is remote?
So just because the worker is remote, that doesn't excuse the employer from having someone review the documents in person. And in cases where the employer, him or herself, can't do that, the employer has to designate an agent. It's very important to designate an agent that you trust because you, as the employer, will still be liable for any mistakes that are made on the I-9. A notary public is the most common type of agent that is designated. Sometimes notary publics aren't familiar with this requirement or don't understand it. And there are some companies that actually offer remote I-9 services. So employers could just Google remote I-9 services and see whether there might be any trusted vendors that they would like to work with. As we said, it's very important that this designated agent reviews the documents in person, and the employer still should double check their work since they are liable. And as the last point, the employer should ensure that they have sufficient time to review and submit the information to E-Verify prior to that deadline.
Thank you, Becky. The I-9 is a 3-page document. It's amazing how many pitfalls there are in the I-9 process, and that it's a 30-year-old document at this point, but there's so many compliance issues. So thank you, Becky, for walking us through that. And SHRM has more resources. Becky has more resources with her firm, and thank you for joining me today.
My pleasure. Thank you.